that lateral support from your neighbor and it causes damage to your property. So the duty of lateral support is not limited to land in its natural state. It also includes buildings on that land. So that is what the court decided. It's not just for the soil that you must protect. If you don't provide the necessary lateral support, it could also be for those buildings on the higher lying land of Mr. D. So whether the excavation, the court then had a look to see whether that excavation had breached the duty of providing support, and were the excavation closely enough linked to that damage or harm that the neighbor suffered. And in this specific case, the court found that yes, you've got a duty of lateral support, and in this instance, it was the excavation that happened on Mrs. P's property when she excavated that caused the damage to Mr. D's property. She did not provide sufficient lateral support, and that is the reason why he suffered damages as a result of that. And in that scenario, Mrs. P was ordered to pay damages to Mr. D that suffered damages as a result of her excavation that caused his land to slide down the hill and cause damage to his building. There's a duty on her to protect and to provide lateral support and to ensure that that retaining wall is sufficiently strong to prevent his land from sliding, and she's liable to repair and pay for the damages that was caused on his property. There's also a common law obligation not to interfere with the natural flow of water and to accept the natural flow of water. So in this scenario, a property owner is not entitled to artificially interfere with the natural flow of water. Example, channeling rainwater in a pipe onto the property of your neighbor. That's not the natural flow of water. Property owner is obliged to accept water if it flows naturally onto his property. So the natural flow of water, you've got to accept the natural flow of water from a higher lying property onto your property. If it's a natural flow of water, you've got to accept it. But your neighbor may not channel the water or use pipes or anything like that so that it's not natural flow of water anymore. And that is the case of Papaladaradu and Howard, which the judgment of the Supreme Court of Appeal. There was a dispute between two neighbors, obviously specifically with regards to this matter. So in this scenario, what happened was, again, a higher lying property and a lower lying property. So the lower lying property built a wall on the boundary between the two properties. So it's a boundary wall that was built. But so what happened was the rainwater would gather here and flood the high lying property of the neighbor because of this wall that was built by the lower lying property. So the higher lying owner said, no, but hang on, you've got to put holes in that wall of yours so that the water doesn't dam up here on my property, because this is the natural flow of water. And you've got to accept the natural flow of water. So what happened was the court had a look at the case and had a look at all the facts of the case, and the law merely provides that natural flow of water must be accepted or must be accommodated by the lower lying property. Our courts will not allow a lower lying neighbor to be forced to contend with an unnatural state of affairs. So in this specific scenario, what happened was the higher lying property that had the issue with the damming up of the water because of this wall that was built, that neighbor paved his backyard garden. So it was totally paved. So the court said, but That is not a natural flow of water. If you pave your back garden, then you increase the amount of water that is going to flow to the lower lying property. It's not as if it's a natural flow of water that there's garden and lawns and flower beds and stuff. If that was the case, then yes, that's fine. But in your scenario, Mr. Neighbor, up the road, you paved your entire property. So there's a hell of a lot of more water that's going to flow from your property to the lower lying property. So in this specific scenario, the court said, no, we are not going to force the lower owner to put holes in his wall so that your property doesn't flood there at the top and to then allow the water to flow to the lower lying property. We're not going to force this lower lying property, the owner, to make holes in the wall so that the water drains from your property to the lower, because this is not a natural flow of water. You have increased the flow of water because you've paved your entire property. So no, that is not natural flow of water. We're not going to force the lower property to put holes in his boundary wall that he built, because that's not acceptance of a natural flow of water. So no, we're not going to agree to that. So on the higher lying property, what you should have done is, when you decided to pave your back garden, you should have made provision for your water to be dammed up against that wall, and you should have made other irrigation or other funnels or whatever to make your water disperse. You cannot put that burden now on the lower lying property and let all this water flow onto his property. So no, we're not going to agree to that. What the obligation in common law is that you cannot stop natural flow of water. And you've got to accept, as a lower lying owner or lower lying neighbor, you've got to accept water if it's a natural flow of water. But in this scenario where the property is paved, etc., that's not natural at all. So we're not going to accept that. We're not going to agree to that. There's also an obligation not to encroach on another person's property. So it can be, I just want to have a look whether I'm at the right. The first thing is for buildings and structures. Sometimes a building might encroach on a neighbor's property. So in the early South African law, the law was that if there's a building or a structure which encroaches on my property, you as the owner, you are entitled to demolish it. Breek het op, gooi weg. However, the current position in the South African law is that you cannot take the law into your own hands. You cannot go and remove a structure that is on your land. You cannot remove it. You have to get an interdict if the neighbor doesn't agree. Obviously, you have to go to court. You have to get an interdict to prevent or stop him from building, first of all, building the structure. But if he's already built the structure, then you've got to get an order from the court to remove that structure or to deal with that encroachment in the best way possible. And if demolition or the removal of the structure is the best way, then the court will grant that order, or an order awarding suitable compensation in circumstances where the cost of removing the structure would be too excessive. So if it's too expensive to remove that structure, then you must be compensated for that structure encroaching on your land. So the court will then make a decision for a certain amount of money, monetary money, to be paid to you by the neighbor to have that right to have the structure on your land. It will go further because your property will have to be subdivided, and that subdivided portion will have to be transferred to your neighbor so that it becomes part of his land. But still, a piece of your land will be cut off. You will get a reduction in your property. So you must be compensated for cutting off 30 square meters from your plot to now give to the neighbor because he encroached with his building and it is too expensive to remove that building, etc., you must be compensated for that. And that is what the court then will decide. But in the old South African law, you were entitled to demolish that property, but you're not entitled to do that anymore. The court must order as to what is sufficient compensation for you. So that is with regards to structures and buildings, but more often than not, the encroachment is plants or vegetation. So when a property owner plants trees, plants trees near a communal boundary wall, there is a duty on him to ensure that the trees are maintained, that they are trimmed, so that the trees do not become a nuisance or does not cause damage to the neighbor's property. So obviously, if you've got trees, you must make sure that you trim your trees. The trees, the branches shouldn't grow over your neighbor's wall and encroach on his airspace, on his property. You should trim your trees in line with his boundary, remove those branches. And if you've got trees that cause havoc in the fact that your leaves are falling in his gutters and it is preventing rainwater, you should clear his gutters for him if that is caused by your trees that you've got in your garden. So if you've got an issue with your neighbor and trees and vegetation causing a havoc on your property because it's overhanging the boundary wall into your property, you've got to ask your neighbor to please trim his trees hanging over the wall onto your property and remove the cuttings. So proceed then to trim the branches. If he doesn't want to agree to that, then you'll have to, and you've provided him sufficient time, please, during the month of February, can you please trim the trees? It's hanging over onto my garden. And if he doesn't do anything, then you will have to go and you will have to trim those branches, but you're not entitled to keep the cuttings or the fruit thereof. Request the neighbor to remove those cuttings, or whether you can throw it onto his garden for him to remove it. But you can only throw it onto his garden if he agrees to it. If he says, no, I don't want that cuttings and whatever that you've cut off on my garden, then I'm not going to remove it either. I'm not going to bring a trailer around and get my garden service people to come and remove it. No, I'm not going to do that. Well, then unfortunately, you will have to do it. You will then have to remove the cuttings, but he is still liable to pay for the cost thereof. So if he's not prepared to trim his trees so that it doesn't hang over your boundary wall, then you have to do it. If he's not prepared to receive those cuttings on his property so that he can remove it, then you will have to remove it. But he is liable for the cost thereof. So for the cost of cutting it, so if you had to get your garden service to cut or trim the trees in line with the boundary, and your garden service people then had to remove the cuttings, the cost of that is for your neighbor's account, because he should be doing that. He should maintain the trees that is planted on his property that is now encroaching on your property. So he's liable to pay for those costs. So we've got issues, and with regards to, we've got case law with regards to plants and vegetation encroaching on other people's, on the neighbor's property. So in Smith versus Basson, overhanging branches which intruded the space above the affected neighbor's land constitutes an encroachment. Of course it does. The aggrieved neighbor can insist on that branches being trimmed and being removed, and further entitled to approach a court for an interdict relief to prohibit any further invasion. So those are your rights. You can ask him to remove it. If he doesn't want to remove it, you can remove it, but he will be liable for the cost thereof. He can also get an interdict forcing him to maintain his trees on his property. Malherbe is a serious municipality. The removal of branches himself, and you can claim the cost for the removal of against the landowner on whose land those trees or those vegetation is. Yes, that is your right. Approach the court for an interdict compelling the owner to remove the branches. So yes, you can get a court order forcing the person to trim his branches or to remove branches and to clear it, etc., if necessary, coupled with a prohibitory interdict forbidding similar encroachments in the future, forcing him to ensure that he maintains his trees, etc. But to get a court interdict or to get a court order to force the neighbor to cut his trees and to remove the trimmings and branches that he cut off, it's a hell of a lot of money. So more often than not, you as the neighbor will trim the trees that is encroaching on your property and ask the neighbor to remove it. If he doesn't want to remove it, then you will remove it and ask him to pay the cost thereof. And obviously, if he doesn't want to pay the cost, then take him to court for a court order that he must pay those costs. So again, encroaching on another person's property, it deals with the same deal with the Grewes property were not planted. That's a matter of Vogel versus Grewel. I just want to have a look here. So Vogel versus Grewe was with regards to the issue of trees resulting in a possible nuisance. It was an issue with regards to overhanging branches. It was causing damage to the vibroquete wall between the two neighbors. The neighbor complained that the roots under the vibroquete then also encroached onto his driveway and caused damage to his paving. And further, that the leaves caused damage to his gutters. It blocked his gutters. It caused damage because his leaves and everything would just fall in the pool and would cause havoc and an absolute nuisance for him. And then Vogel then applied to the court for an order to have those trees removed. So the trees were on the boundary between the two properties, and Vogel asked the court that the trees be removed. The court then obviously had a look at the trees on the Grewes property, and they found that the trees were planted about 2 meters from the boundary. So it was a reasonable distance between the properties. The court indicated that on the evidence, it appeared that the concrete wall was not seriously damaged. It would have been very easy just to repair the vibroquete or the concrete wall boundary. It would not be unreasonable to expect the parties to repair rather than to remove the trees. It was convinced that other less drastic measures could be implemented to make the problem instead of removing the trees. The problem could be resolved by way of Vogel requesting Grewe to prune his trees. So that application for the removal of the trees was denied by the court and said that no, there are far less invasive, intrusive ways of resolving this issue than to force a person to remove the trees. It is quite easy to repair the damage to the wall. The court also found that there was no evidence shown that it was the leaves of these trees that blocked the gutters. The court said that there are lots of trees around in that area. You never once showed evidence that it was the leaves of this neighbor's trees that caused damage to your pool or to your gutters. Never. It also said that, but you never showed any proof that the damage caused on your driveway was specifically from the roots of these trees. There's no evidence to that effect. So the only thing that we really need to consider is the damage to the vibroquat wall. Is it really that necessary to remove the trees as a whole, or just to repair the vibroquat wall? It's much easier just to repair the vibroquat wall because it's not a hell of a lot of damage against the vibroquat wall in any event. But the point is, if everything else fails, you have to go to court and bring a court application for the court to decide whether or not it's reasonable or not reasonable, etc. You've got to avoid a dangerous situation arising on your property. So you've got to avoid a dangerous situation on your property that might cause damage or injury to anybody entering onto your property or to a neighbor's property. So if we have a look just quickly, a property owner is obliged to take reasonable precautions to avoid the possibility that other people may injure or suffer damages as a result of a dangerous situation on your property. In this specific scenario, NTO Forestry sued Mr. Swart. Again, the forestry company had a plantation with trees that was their business, and Mr. Swart had the adjoining farm. It was farmland. What happened was there was a fire that moved from Mr. Swart's farm into the plantation and caused 23 million rands worth of damage, according to MTO Forestry, in loss and damage to the plantation and the loss of trees, etc. And NTO Plantation then sued Mr. Swart and said, but Mr. Swart, you didn't take any precaution to prevent this fire from coming onto our plantation. And the court just said, but it was an act of God. Mr. Swart didn't start the fire on his farm. It was natural causes that caused the fire to start. It might have been lightning and whatever. Mr. Swart did have a fire break on his land between the two properties. So there was no negligence on Mr. Swart's side. He took all the reasonable steps he could to prevent any danger from coming from his property onto MTO Forestry's property. There wasn't anything else he could do. He wasn't negligent in any way. So MTO Forestry, you don't have a claim against Mr. Swart because Mr. Swart didn't start the fire. It was a natural occurrence. It was an act of God. It was started by lightning. Mr. Swart there's no duty on Mr. Swart to stop the fire and to prevent it from going over into MTO Forestry's land. That is impossible. He did the best he could with a fire break on his farm, but other than that, there's nothing else he could do. So Mr. Swart took all the steps that he could to prevent harm to the neighbors as a result of a dangerous situation arising on his property. So each and every case, they will have a look at the facts and they will have a look to see what's reasonable, what's not reasonable, and the court will then make a decision based on that. So that is it, guys, about neighbors, encroachments, buildings and plants, and noise pollution, water flow, the natural flow of water, etc. So if you've got any questions or queries, please feel free to email me or contact me. Thank you, Michelle. Thank you, Leapfrog. I know I've gone over the time a little bit, but yeah, next time I'll make it up for you guys.
No stress, Hein. Thank you so much. I think that was very informative because obviously there is always a lot of disputes with neighbors about plants encroaching. It's all very nice if you've got like lovely lemons hanging or avos or
Absolutely.
something.
Then you can go and pick it. Absolutely. Thanks, guys. Thank you, Michelle. Have a great week.